So we've got some great content to cover today. Travis Tallarico is joining us. I'll turn it over to him in just a minute from our Rochester office. And of course, Katie Anderson will be giving our usual Albany update. Before we do that, I thought I would just give you a quick overview on what's going on my desk right now. People seem to have been interested in this, so I thought I'd try another installment here. Welcome your feedback, and again, welcome your concepts for other ideas too in our program. What I'm seeing across my desk is kind of more the same on what I've reported before. At this time, I'm seeing, again, an increased level of enforcement from the New York State Department of Labor, in particular on wage and hour type cases. I'm seeing more and more of those cases. In some instances, these are cases that sat for several years, and sometimes as long as 3 and 4 years, believe it or not, and others where these are new investigations that are just starting and just ramping up. So again, if you have one of those pending cases, keep your eye on it. And if you haven't heard anything, you likely will soon. And also, if you do get a new case, they seem to be now moving forward with these cases in a more rapid fashion than had been done previously during the pandemic. Another issue that I'm seeing that I wanted to mention, I have what I refer to as kind of these repeat or serial claimants before the New York State Division of Human Rights. Handle a number of these cases with these repeat claimants, and they are, for the most part, individuals who have pretty extensive or serious criminal histories, and they will scour the internet looking for job postings that employers put out that screen out expressly individuals based on their criminal history. So it'll say something like, hey, a clean criminal history is required, or a clean criminal history check is required. Historically, they've used those postings as the basis for a New York State human rights law claim. In essentially that the employer, it's evidence of the employer not performing the analysis that's required under Article 23A of the corrections law to duly consider an individual or candidate's criminal history, weighing the statutory factors and then making a determination based on those factors. So I just mentioned this, and for a while these claimants were not even applying for the jobs in question. Their position was that it was sufficient that the posting was made and that they were harmed. In defending a number of these cases, we pushed back on several different fronts from a legal standpoint, particularly where the individuals were not even applying for the jobs. And eventually, the State Division of Human Rights relented to an extent and did require, or at least did find where there was no application that these individuals were not aggrieved. I suspect since that time, they are applying for the jobs and preserving the aggrieved individual's status ostensibly. And again, I think we still see these job postings from time to time, which can be problematic. So to the extent you have them out there, I just wanted to mention this. Again, where it becomes a potential issue is where you have a job posting that says you're required to have a clean criminal background or a clean background check. Those can be potentially problematic. And if we can help address those issues and how to craft the language properly, we'd be happy to do so. What I'm also seeing are employee handbooks. Again, it's the end of the year, seeing a lot of employee handbooks come through for review. Always a good time of the year to do this. I do get a question from time to time as to, hey, do you have a checklist of the newest and latest things that we need to have in that handbook? I don't have anything quite like that. And again, it's going to depend in part on what you already have in your handbook. But some of the things that I think I would just flag for you here is one, there are some expanded classifications that are now protected under state law. That would include reproductive health decision-making here in New York. In addition, employers need to have a policy in their employee handbook now with respect to employees' reproductive health decision-making. The voting leave law, we've seen changes going back and forth in that law. It had been on the books for many years. Then there were changes expanding the voting rights, and then the statute reverted back to its original form for the most part. So again, making sure that your policy on voting leave is the right one and not the old one, the second old one, I guess, the new old one in your handbook. In making sure that the updates that have been put in place under the New York human rights law, particularly dealing with sexual harassment, that those changes, and in one in particular, we're talking about a statute of limitations, that those changes are reflected in the sexual harassment policy required under state law that you have in your handbook so that you have the correct information. Additionally, there's been a change, as we've reported on previously, as to the standard for what constitutes actionable harassment under state law, and making sure that your policies reflect that standard, which under state law is no longer the severe or pervasive standard that exists to date under federal law. So those are a few of the changes that just finally, again, it's the end of the year, so we're seeing employee training on harassment and workplace sexual harassment. I'm doing quite a bit of that. And I just should mention too that bond has updated and has available for clients its online training portal that satisfies the state and New York City sexual harassment training requirements. It's a great program that we worked hard to put together, very affordably priced, and I know a number of our clients have taken advantage of that. If you have interest in that, feel free to reach out to one of us. Okay, well, we always ask you to let us know about topics that you're interested in hearing on. And we heard loud and clear that COVID-related leave was one of those topics. So I've asked Travis Tallarico, I should say, Travis offered to join us today and to present on this topic. Travis works in our labor and employment department here at Bond, out of our Rochester office, somebody I work with frequently. And Travis, it's great to have you today. Thanks for joining us.
Yeah, of course, Andy. Thanks for having me, and happy to be here. So a good chunk of what we're going to be talking about today, a lot of it isn't necessarily new information. It's been some guidance that's been out for pretty much most of 2021, but definitely think it's topical and timely to be reviewing some of this and some of the new things that have arisen since the updates came out earlier this year. So let's get right into it. So I'm assuming that most everyone is familiar that any federal leave laws regarding COVID-19 are no longer in place, done away with at the beginning of this year. However, here in New York State, we still have several pretty topical leave laws: vaccination leave, specific COVID-19 sick leave, or otherwise referred to as quarantine leave. And I'll also be addressing how New York paid family leave can possibly interplay with COVID-19 related leave. So again, this is probably nothing that is a surprise or new information, particularly for most of us on the call here. But beginning in March of 2021, New York State issued COVID vaccine leave, and this is in place until December 31st, 2022. So that's something that some of us might not be aware of, and to be keeping in mind is that for at least the next year, this law is going to be effective and in place. All employers must provide up to 4 hours per injection to get the COVID-19 vaccine. And so for Moderna and Pfizer, that require 2 doses, that's up to 8 hours. Johnson & Johnson, up to 4. Probably the newest piece of information that we might not have been aware of is that the Department of Labor earlier this month did issue guidance clarifying that paid leave is available for booster shots as well. So now that would be up to 12 hours for Moderna and Pfizer, and another 4 hours for Johnson & Johnson. And the guidance is still clear that this leave is only available for the employee to receive the vaccine themselves, not to take a family member to the appointment or anything like that. And also time that's accrued under New York's paid sick leave can be used to take for recovery time for any sort of vaccine or booster related side effects. And also important to note that this is a job protected leave and retaliation is prohibited. Now, I think this is a topic that some of us might not be as familiar with, and I think is actually going to be pretty topical moving forward, as unfortunately COVID continues to linger, especially now that there's been some breakthrough cases. It's definitely something that all employers should be aware of, and particularly as we'll see on the next slide, what category they fall into and their obligations for employees who are subject to quarantine orders due to COVID-19. So currently there is not a set termination date for this type of leave. So this is going to be around for the foreseeable future. And all employers are mandated to provide leave for an employee who is subject to a mandatory or precautionary order of quarantine. This applies to both public and private employers. And the next slide is going to illustrate different categories of employers and how those are treated. So we'll take a little bit of time to walk through this chart here because the size of the employer, their status as public or private, and actually the income that a company makes is relevant in determining the employer's obligations for providing leave under this act. So for companies with 0 to 10 employees with a net income of $1 million or less in the prior tax year, the employer themselves is not obligated to provide any, and when I say not obligated to provide any leave, they're not obligated to pay for any leave for the duration of the order. However, the employee is entitled to apply for and collect combined COVID-19 paid family leave and disability leave for the duration of the order. And note that those benefits are capped at roughly about $2,800 on a weekly basis. Now, for the next two categories, for 0 to 10 employees with net income of more than $1 million in the prior tax year, or private employers with 11 to 99 employees, the employer is obligated to provide 5 days of paid sick leave for the first 5 days that the employer or the employee is subject to the quarantine order. And then after those 5 days are provided, then the employee is eligible to apply for the paid family leave and disability leave discussed previously. And then finally, for 100 employers, private employers with 100 or more employees, and all public employers, the employer is required to provide up to 14 days of paid sick leave. And that obligation falls solely on the employer to provide that leave. One thing that's important to note here is that this sick leave is in addition to any other leave provided for under state law. So for example, this leave would need to be given on top of any prior existing sick leave that had been accumulated for the employee or by the employee. Next slide, please. So at the beginning of this year, the New York State Department of Labor had published some additional guidance regarding this particular type of quarantine leave and expanded the obligations of employers, which I'll be going through on the next couple of slides here. So this guidance clarified a few things. First, if an employee tests positive for COVID-19, the employee cannot report to work and is automatically deemed subject to a subsequent mandatory order of isolation from the Department of Health and is entitled to paid sick leave under the New York State COVID sick leave law, even if they already received sick leave for the first period of the mandatory quarantine or isolation. Now, I'll be getting into this on the second slide or on the next slide, but this guidance that was released back in January sets forth that this leave can be used on more than one mandatory or precautionary quarantine order, but subject to a couple other obligations, which will be on the next slide here. So this leave is only available for use by an employee 3 times. And the second and third uses of the leave must be based on a verified positive COVID-19 test. So if an employee is subject to a mandatory quarantine order a second or third time, to receive the benefits, they are obligated to provide verification of a positive COVID-19 test. Now, a very important distinction to make here is that an employee who is subject to a quarantine order but is not showing symptoms and is able to work remotely is not eligible for these benefits. Now, obviously, that might be a little bit tricky and difficult to parse out regarding, showing the symptoms. That's more so for the employee to kind of represent themselves, but it's definitely worth pointing out that this leave is subject to some limitations. Now, another thing that the guidance that was released back in January pointed out is that there is an additional obligation for employers to provide paid leave, even if the employee is not subject of a mandatory quarantine order, and the employer mandates that the employee not report to work due to the employee's exposure or potential exposure to COVID-19, regardless of whether the exposure occurred as such in the workplace or not. So, for example, this is a case where if an employer has an employee comes up, mentions that they were exposed to COVID, and the employer makes their decision to hold the employee out from work, the employer is, and again, this is if the employee is not able to be working regularly remotely from home, the employer is obligated to pay the regular wages of that employee due to their directive that that employee remain home from work. And that wage must be paid at the employee's regular rate of pay until the employee can come back, or until the employee does become subject to an order of mandatory precautionary order, at which point then the leave that was discussed previously would kick in based on the size of the employer.
Travis, can I jump in there just
Please.
real quick? Thank you. This is great. We're getting tons of questions on this too. Too many, unfortunately, to be able to answer readily here, but I want to just go back and make sure I got my head screwed on straight on what you're talking about here. So we go back. There is a statute that was enacted, way back when COVID started, that said, hey, if somebody's subject to a governmental quarantine order, they're entitled to certain leave during that quarantine period, right? So I think I've got that in that statute. I think way back when we were all thinking this would be over in 2 weeks, or there, certainly wouldn't be successive instances of leave, and the statute really didn't address, if more than one, if it was one, more than one, or how many. And the state came back with the guidance that you mentioned and said, hey, it's up to three periods of leave that can be available to an individual. And for the second and third leave, the employee themselves actually have to test positive for COVID and be subject to governmental quarantine order. So we're good. Am I right on all fronts there so far?
Yeah, and my understanding is that the testing requirement is going to be a lot more relevant when they're reapplying for the paid family leave and the disability benefits for verification there. But yes, the guidance is clear that the employee does have to provide a positive COVID-19 test for verification for the second and the third leaves.
Okay, so if I'm subject to a quarantine requirement because maybe one of my kids tested positive or was exposed, and I'm not positive for this, not experiencing symptoms, then I would not be covered for that second or third potential scenario, right?
That's my understanding. Yes.
Yeah. Okay. So then, so what we have here, right, is this uncertainty in the statute and the state providing some of its interpretation as to this. You get 3 shots at this leave. The point you just mentioned a minute ago, it also requires an employer, if they send an employee home for having been exposed or concerns about exposure, then the benefit obligation would be triggered in that situation too. We've worked with a number of clients on this in the past, and I think it bears reiterating at this point. This is something that goes well beyond what the statute required in the first instance. The statute very specifically spoke about a quarantine order, right? And employees are subject to a quarantine order. And the guidance that says, hey, if you're concerned about somebody being exposed and you send them home, you have to pay them this COVID leave. I've read that to date as going beyond quite clearly what the statute contemplated. I think it's important for us to mention that. And again, it's not uncommon for those viewing this webinar, if you get a call from the Department of Labor, from the Attorney General's office, that representative might have their own view of how the statute should be interpreted. And again, I just want to encourage everybody to make sure they understand these distinctions, understand where it's guidance being provided. Travis has laid this out, I think, perfectly. But it's an important point to reiterate here that, again, in this last instance, the guidance really exceeds what the statute requires. So sorry, and if you disagree with any of that, Travis, let me know.
No, not at all. I actually think your question there, Andy, kind of set me up nicely for this last slide here, which is the interplay of paid family leave in some different situations here. So there has been clarification that New York State paid family leave is available to care for a family member, and listed out there specifically a spouse, domestic partner, child, stepchild, parent, step-parent, parent-in-law, grandchild, or grandparent diagnosed with COVID-19 deemed to be a serious health condition. Now, there's a couple things to kind of parse with this one. Is the last part of that, the deemed to be a serious health condition. My understanding of this is to be eligible for paid family leave is in order to care for a family member who is sick with COVID-19, that family member, it would have to be deemed that COVID is deemed for them to be a serious health condition as defined under the regulations. And there's information particularly detailing what a serious health condition is available on the Department of Labor website. But so I don't think that this is necessarily automatic that someone maybe would be 100% eligible for paid family leave. But it appears that definitely if a family member's diagnosis was of a serious health condition, then they could be eligible for that. And then this last bit ties in well with Andy's question earlier, is paid family leave also may be used to care for a minor dependent child who is subject to a quarantine order and to care for that child. Although, again, there is a exemption that if the employee is able to work remotely, they're not eligible for leave in order to care for a child who is subject to a quarantine order. And so I think that's about all I got. I'll parse through some of the Q&As I haven't had a chance to look at yet and see if I can answer at least a few of those while Katie's providing us with her always wonderful updates from Albany.
Hey, Travis, thank you. Good segue too, bud. Well done. Thanks for the feedback and very helpful information. Folks, we'll make sure you get these slides. We've gotten a number of questions on that. So, Katie, how are you?
You know, I'm here. I'm doing it. I told you all last week I was going to get my booster shot. I did. So here I am.
Well, good job. Thanks for joining us. I know a lot's been happening in Albany in the last couple of days. I guess not all of it. Well, some of it very interesting. Perhaps not all of it worthy of a deep dive here on our webinar for our clients. But thanks for being with us again today, and take it away.
All right, I will. And one thing to note too, I know there's a ton of paid leave questions in there, and that's great. A lot of them are super specific. So if you have a specific question, those are ones that you're going to have to reach out to an attorney separately to get an answer to, just because I see the volume of questions in there, and we're going to want to make sure that it's covered the correct way. So reach out to a bond attorney and we can try to get you some help. All right, moving on. I wanted to include this right up front because this was the headlines of today from New York State. I use a website called empirereport.com. It aggregates all news stories about New York into one, website area. And these are all the headlines that I woke up with this morning. Lots and lots of COVID updates for all of you. So let's get it started here. We're going to be covering all of those things that are listed there, except for the Ulster County specific issue. So looking at this map, we're seeing a little bit of a nosedive here, right? In terms of positive cases in New York State. Don't get your hopes up about that. That is the Thanksgiving nosedive. That is, everybody was hanging out with their families. You were only going to get tested if you felt symptomatic. You weren't going to get tested otherwise. So what, I expect is going to be happening is we're going to see a pretty sharp shot up following the holiday. Next week, I'm pretty sure we will see that. In the meantime, looking at what's happening with hospitalizations is something that I'm, very concerned about. So while this is the aggregate, it takes the average of how many people are hospitalized over the past 7 days. The hospitalization, rate generally has increased by about 200 people since last week. I know that number is not reflected on this chart. That's because we're looking at different numbers for that, but that is concerning. We are seeing hospitalizations soar in New York. And while, there's a lot of things that we have to worry about, that's going to be our number one issue. So looking then at what we're doing with vaccinations, there hasn't been really any change since last week. I did want to include this number in here. I don't usually, but I thought it was worthwhile to throw in there. Looking at age 65 and older, for New Yorkers, we have 99% have received one dose of the COVID vaccine. So that's phenomenal. That is the age group, obviously, with the highest number of people that have received the dose. One thing to remember is that the CDC and New York State now has come out and said that if you are over the age of 50, you really should be going to get a booster shot. And you received, either Pfizer or Moderna 6 months ago or Johnson & Johnson 2 months ago, you should really be going to get your booster shot if you're over 50 especially. But everybody is being encouraged to go and receive them. Looking again at where our hotspots are in comparison to what our vaccination rate is. This map, again, is very illustrative. It really illustrates the issue here. Looking at places where there's generally high vaccination rates, the rates of COVID are lower than in other places. But one thing to really note here is we have some real trouble areas in the capital region. Washington County is, it's not going well. Warren County as well. And then out in Western New York, that has been a very concerning area. And so continue to, be mindful of what is happening in your area. And I'll discuss that a little bit more in a second. So last week, the governor issued a state of emergency, an executive order for COVID-19. We went 5 months without one, and here we are again. We now have another state of emergency for COVID. What does that mean? So one big thing to note right up front is that this executive order is very different from the executive orders that we saw under Governor Cuomo. The legislature revoked a lot of the power that it had granted to Governor Cuomo at the time in this year that forbids the governor from issuing directives. It still allows a governor to issue suspensions or modifications of laws or regulation. That's normal for states of emergency. But what was extraordinary in March of 2020 was that the governor was given the power to issue directives. That's how we saw things like the universal mask mandate across New York State. That is a big difference between then and now. So whether or not the governor now has the authority to issue something like a universal mask mandate, it does seem doubtful because that was issued under the governor's authority, that previously existed. That authority doesn't exist anymore. The state would need to try to find a creative way to issue a universal mask mandate. At this point, it seems unlikely. It does appear that the governor is leaning hard on local communities to issue their own mask mandates. But I will talk about that in a little bit as well. So why was this executive order issued? As I noted earlier, hospitalization rates are in a really critical areas. The hospitalization rate is not at a good place. We are at near capacity in many hospitals near or at capacity, especially out in Western New York, and in the capital region as well. So that's the reason that this was issued. So what then does the order do? This is not a long executive order. It's very straight to the point. The executive order allows for the implementation of surge and flex. What does that mean? It means that the governor can say we're postponing all non-elective surgeries, non-essential elective surgeries, excuse me. We're definitely not postponing non-elective surgeries, but they're postponing non-essential elective surgeries if there are less than 10% of staffed beds available at the hospital. In other words, the hospitalization capacity is at or above 90%. 90% of the beds are full, or 10%, less than 10% of the beds are empty. Either way you look at it, it's not great. Yesterday, according to Governor Hochul, there are 30 hospitals that meet that criteria to stop doing elective surgeries. They are primarily located in Western New York. Looking though to what else the executive order does, it also suspends certain provisions of the state finance law regarding government contracts. This is to allow the state to access PPE faster, more tests, more vaccines. Those types of things we've been talking about for almost 2 years. I'll be able to say next year. What else does it do? And this is critical. This executive order gives the governor the authority to deploy the National Guard. So the governor has decided to deploy National Guard members who are trained as EMTs to work within nursing home and long-term care facilities in hotspot areas. Why? Because one of the reasons, according to the governor's press conference yesterday, one of the reasons that hospital capacities out in, Western New York, for example, are so high is because you have nursing home residents or adult long-term care facility residents who were hospitalized because of COVID, recovered from COVID, but can't go back to their nursing home or long-term care facility because they just don't have enough staff at those facilities to take care of them. So one hospital executive said that if this went into place, they had 50 beds that they would be able to free up because those people would be able to go back to their residence and get out of the hospital and open up those beds. So that is why that is happening. In addition, the governor also announced that beginning in January, National Guards members will all be beginning training as EMTs. Every National Guards member she wants to see certified as an EMT. Because right now they're only taking those ones that are certified as EMTs. So that will hopefully relieve some pressure, but there are lots of concerns, otherwise that there will be, not enough people working to relieve that pressure. So as you can see, just from a 5,000 foot view, the strategy of Governor Hochul greatly differs from the strategy we had under Governor Cuomo. This is not so much a top-down approach anymore. Her approach, as she has stated over and over, has been, I'm going to collaborate with local governments. Local governments, you tell me what you need, and I will get you what you need. For example, Warren County, Warrensburg, up in the capital region said, we need the mass vaccination and testing site reopened. And the governor announced that they were reopening that. I expect we're going to see more of those mass testing and vaccination sites reopen over the coming weeks. So that's one thing to be keeping your eyes on. The second issue here, though, is will that strategy of collaboration rather than the top-down approach continue with the new Omicron variant? So the Omicron variant, lots of people have had issues pronouncing it. I may have an issue pronouncing it. I keep getting it confused with Omarion, the R&B singer. So that tells you where my head is at lately. It was designated as a variant of COVID, a credible variant by the World Health Organization on November 26th, the same day that this executive order came out. What do we know at this point? We only know that we don't know much. It was first detected in South Africa, but today the Dutch government, the Netherlands, announced that they have been, now sequencing samples that they received prior to November 24th, and have found that this new variant was in the Netherlands as of November 11th. It has not yet been found in the United States. I would have to assume, again, you all know me, I am not a doctor, a medical doctor in any way whatsoever, but I have to assume it's here already if it was being floated around in Europe on November 11th. You just have to assume that it is here. We live in a global world now. So the US has issued travel restrictions for non-citizens from 8 countries, noticeably, none of them include where it was started, but that is where the travel restrictions exist for now. I don't know how long those travel restrictions will be in place for. As we've seen, the travel restrictions, it may just be too late in the game to have these travel restrictions in place. And I think most people are done with travel restrictions at this point. So that's the update on that variant. I will continue to, provide updates on it as we know more. I'm sure next week we will have more information. Looking then at what's happening in New York City. In New York City, the Commissioner of Health issued a mask advisory yesterday. It's not a requirement. It is a strong recommendation that indoors in New York City, in public places, everybody, regardless of their vaccination status, wear masks. This was issued because of this, we're seeing a surge. The vaccine mandate, though, there is a new one that was issued yesterday in New York City for childcare and early intervention programs. This would cover around a little bit over 100,000 employees in New York City. So, we may see more and more vaccine mandates. We have seen many as we've gone, but we will see what happens next. Finally, New York City has authorized that children ages 5 to 11 receive their second shot beginning this week. So prior to this week, they were saying, okay, we're going to wait a little longer to give people, to give children their second shot. This week, they said, let's just roll it out. People want to get the shot, so let's give it to them. And that, I believe, was my last slide, Andy. So I will throw it back to you.
Katie, thanks. Thanks for the update as always. Hopefully, there seem to be some initial reports that the Omicron variant, the symptoms are consistent with what we've seen, but perhaps milder than with other variants. Hopefully that plays out and is taken into consideration. All right, everybody, thanks again for joining us. You see our contact information there. If you have any questions, reach out. If you can stay on for 30 seconds and do the survey, we would greatly appreciate it. We welcome your feedback. In the meantime, be safe and be well. Thank you.